Welcome back. Today, we're diving deeper into a case that's before the Supreme Court that could fundamentally change adoptions involving Native American children. The case has been combined into what's called Brachine versus Holland and centers on the Brachine family out of the DFW area. They're arguing they were initially denied adoption of a Native child they were fostering because of the Indian Child Welfare Act, or ICWA. In less than a month, their legal team will argue in front of the Supreme Court that ICWA is discriminatory and unconstitutional. That's the Brachine family there. Let's talk with attorney Alexis Gardner now about this case and the potential fallout. Good morning, Alexis.
Good morning, Dave.
Starting off with ICWA, some of our viewers may remember 10 years ago here on Channel 6, we covered extensively a case involving the Indian Child Welfare Act about a child named Veronica who was trying to be adopted, and ICWA came into that. So in terms of the Indian Child Welfare Act, what are we talking about when we refer to ICWA?
Okay, so ICWA basically governs the out-of-home placement of Native American children. And essentially in 1978, the federal government recognized that Native American children were being removed from their families at a much higher rate than non-Native children, and sometimes without evidence of abuse or neglect that would rise to the level of a removal. And almost on the whole, they were being placed with non-Native families, and up to a certain point in boarding schools and what have you. So Congress said, all right, here's what we're going to do. We're going to have standards, federal standards for the placement of Indian children. And number one, the preference should be that if they can't stay in their home, they need to go to a family member. And even if that family member is not Native, but it's kind of a universal truth that children belong with their families. If they couldn't be placed with a family member, then they should go to another tribal family. And if they couldn't be placed with another tribal family, then go to another Indian family if they're members of a different tribe. And then obviously if none of those preferences are able to be achieved, then at least the tribe should have input on what foster placements the children go to. And so essentially this was monumental in Native American culture and their rights, because there's been a consistent loss of language and culture and community. So the tribe said, we don't want, our membership dwindling any further. We want to know where our members are.
And this is the video you're seeing involving that case of the little child named Veronica that we covered here in Oklahoma 10 years ago. So in terms of Brachine versus Holland, I understand there were several different cases that were kind of combined into one for oral arguments in front of the Supreme Court, now known as Brachine versus Holland. What are both sides essentially arguing, even though it's been combined into one?
Well, so there are several parties on both sides, right? There are the Brachines, which you mentioned, and then there are states, Texas, Louisiana, Indiana, that are essentially saying it was unconstitutional. Federal government, don't come in here and make us tell DHS what to do. DHS will place our children, Native or otherwise. They shouldn't have special preferences. Those states are unlike Oklahoma, and they have very small Native populations. So that's not at the forefront of their priorities, right? And then there's the individual families, which are non-Native families who wanted to adopt Native kids, and the tribes preferred that those children go with other tribal members. And then there's the other side, which is Holland is the Minister of the Interior, which is over the Bureau of Indian Affairs and the hundreds of recognized tribes. And there's those parties saying, look, Native American kids are still 2.5 times more likely to be removed from their homes than non-Native kids. So up until just 45 years ago, it was still an issue, and it's still an issue today. So we need to protect our greatest asset, which is their children, right? And without this law, they're going to see further dwindling of their culture. And they're saying this isn't a race-based argument. Native Americans are a protected political class of people, right? And so as their own sovereign, they have a significant government-to-government relationship with the U.S. federal government. And it's not about race, but it's about them as a people protecting their people.
So those are the two sides of the argument there, and Secretary Holland, as you were referring to. So the last question is, and I think folks at home may be wondering, okay, so when the Supreme Court decision comes down, if they rule on it, if they don't kick it back to the lower courts, well, I guess that's one of the answers. What are the things that the Supreme Court could do with this case?
Well, as you said, they could do a number of things. They could strike it down completely. They could declare ICWA unconstitutional completely, and they can pick and choose different parts. But one particular issue is that of parental rights. One of the families was chosen by the biological Native American mother. She said, I want my child to go with these non-Native family. The Native American father, who was from a different tribe, stepped in with his tribe, and they said, no, we want the child to go with our tribal family. So they might carve out special provisions where the parents have more of a choice as opposed to the tribe, but we'll just have to wait and see.
And a lot of times Supreme Court decisions will come down in June and the oral arguments start November 9th is what I was seeing. So very complicated, but Alexis, I think you broke it down beautifully and really helped us understand more of this. Thank you for your time.
Thank you. Thank you, Dave.